I would like to go ahead and get started and welcome everyone to the College of Law. My name is Janet Levitt. I'm the Dean. And this is actually our 6th free lunch CLE. It's our 5th Faculty Showcase series of the year. And this week we also showcased an alumni who gave a wonderful talk. Many of you, I recognize many of the faces, were here on Monday about the financial crisis and the role of the SEC in maybe creating and possibly fixing the financial crisis. I am going to start with an apology that I am going to eat and run. I have a 1:24 flight, but I rescheduled my flight specifically because I wanted to introduce our featured speaker today, who is Professor Jamie McDonald, who I consider a true homegrown hero. He grew up in Tulsa. He went to Booker T. Washington High School, then on to Harvard, where he excelled academically and on the soccer team. From there, he went to the University of Virginia Law School, where he did extremely well, was on the law review, won awards for his note. For there, went to clerk on the 6th Circuit for the Honorable Jeffrey Sutton. And it was when he was clerking that I started chatting with him. One of our professors, Marguerite Chapman, alerted us to this Tulsan who was highly, highly qualified last year. And while he was clerking, he got a call to go interview with the White House Counsel Office, worked in the White House Counsel Office for about 9 months at the end of the Bush administration, and then joined us as a visiting assistant professor of law, teaching constitutional law and foreign relations law, both issues that he dealt intimately with as a clerk for the judge, but also from the White House Counsel's office. One of the most touching moments that I've encountered in the law school was walking in the front doors, running into Jamie's dad, running into Jamie after just receiving a call from Chief Justice Roberts offering him the clerkship. It was a precious moment of pride between father and son, and certainly pride that I have in being able to have Jamie here for a semester. I will say that in my interactions with Jamie, he is not only so well accomplished, and I guess the Tulsa World story says he's only 26, so much that he's accomplished by age 26, but also so highly decent and so highly approachable and just a fun person to go chat with. It's been a real pleasure having him here, and I just want to read a quote that he wrote that he said and that the Tulsa World reported, which I think is so interesting and so important for us to think about, of the role of lawyers in very high levels of government. And he said, at all points, and this is during the Bush administration, at all points we were lawyers, we were not politicians. And I think that is so honorable and so important for us to remember about the role of lawyers in government. So I'm now going to turn the podium over to my colleague, Jamie McDonald, and I'm going to have to run out and catch my flight. So thank you.
Thanks, Janet. Before I begin, I want to thank you all for coming. And I see a lot of the members of the TU Law faculty here, and I want to give a special thanks to you guys, most immediately for giving me the chance to speak to all of you today, but also for giving me the chance to come here as a semester as a visiting law professor. You know, when I finally got my head around the fact that I was going to be teaching 2 new law school classes at a new law school, I sort of felt like that old guy who was driving home on the highway one day and he gets a call from his wife who warns him, hey, there's some lunatic I heard on the radio who's driving the wrong way down the highway. And he says, wait, I can't talk right now. I got 200 of those lunatics driving straight at me. And I thought, you know, as a new professor, you can sometimes feel like the guy driving the wrong way down the highway, but I've had these folks on the CU faculty who've made sure I get pointed in the right direction, so thanks to you guys. As you know, as Janet said in the introduction, one of the courses I'm teaching is foreign relations law. I think it's the first time that it's been taught here. So I want to start with a few basics, a few points of background. And I guess where I'll start is with a definition of what is foreign relations law. You know, the point of the CLE is foreign relations law and overview. Foreign relations law, at least as I see it, is the study of how United States law governs the nation's foreign relations activities. It has a structural focus. What I mean by that is that it's primarily about how the Constitution allocates decision-making authority for legal issues concerning foreign relations. Now, that doesn't mean that we don't spend any time on the actual decisions that were made. Of course, to study the allocation of decision-making authority, you got to study the actual decision that was made. My point is that the field of foreign relations law is more concerned with the structure by which the relevant decision was made than it is about the actual decision that was made and whether it was a good one from a policy standpoint. Now, Janet read that quote from the Tulsa World, and I want to say just a couple more words about that, because I've just told you what foreign relations law is. I want to tell you what it isn't, at least from my perspective. Foreign relations law, and this is at the risk of stating the obvious, is a legal field. It's not policy or political science. One of the lawyers I worked for in Washington was fond of saying, we're lawyers, not politicians. Good lawyers make bad politicians. Good politicians make bad lawyers. And with a couple notable exceptions for my friends Robert and Gary here, I think that sentiment's right. I'm constantly striving, when I'm thinking about issues in foreign relations law, to keep that distinction in mind. So a response to my view might be, well, how about this situation or that situation, or where the line gets blurry between law and politics? And I concede that there are difficult questions, that there are difficult situations where the line between law and politics might not be perfectly clear. But to say that the attempt to distinguish law from politics implicates some difficult questions at the margin, in my view, isn't worth abandoning the exercise. And indeed, I think in some ways, it's the very exercise itself, the conscious attempt to separate law from politics, that's important in this field. So that's a bit of sort of where my perspective, my starting point when I'm approaching foreign relations law. But before we delve into the substance, I want to say a word about the scope of the lecture I'll be given for the rest of the hour. When you hear foreign relations law, you probably think post-September 11th government actions, the wars in Afghanistan and Iraq, the global war on terror. Foreign relations law, however, rests on a legal framework and the legal precedents arising from that framework that have been around a long time, for more than 200 years before September 11th, 2001. I'm going to focus today, for the most part, on the field of foreign relations law in the broad sense, foreign relations law writ large. We'll touch on some of the recent post-9/11 precedents, but my goal is to give you a broad overview of foreign relations law, as broad of an overview as possible in an hour. So we'll focus less on the war on terrorism and more on the background cases and principles that serve as the foundation for foreign relations law. And there are two reasons I want to take this broad view. The first reason is a practical one. In an hour, it's just simply not possible to get a broad overview of foreign relations law and get deep into the legal questions presented by the war on terror. The second reason is that the arguments surrounding these post-9/11 questions, the answers to those arguments will rise or fall based on one's understanding of the foreign relations law precedents that have developed over the course of our nation's history with roots in the founding era. In other words, before we can begin to assess these post-9/11 events, we have to understand the foundational precedents in this area. Though we'll certainly touch on some of the post-9/11 stuff, my goal is to give you the tools to evaluate the legal questions and the political questions, if you're interested, for yourself. So that's the background. Now to the substance. This being an overview, I thought, what better way to start than the beginning? So we'll start with the founding. To find relevant founding materials, we look to the Constitution itself, the Federalist Papers, the Constitutional Convention, the state ratification debates, and other sources. But we also look even further back than the Constitution. We look to the Articles of Confederation. And I really think that to understand the important role that foreign affairs played in the drafting of the Constitution, it's important to understand what the framers thought were the inadequacies of the Articles of Confederation. After all, they scrapped it and they built a new framework for the government. For example, under the Articles of Confederation, there was no executive branch. Rather, foreign relations powers, to the extent they were vested at all in a national body, were vested in the Continental Congress, which was a collective body. The national government also had no general commerce power and no foreign commerce power. In particular, the national government couldn't threaten retaliation against trade restrictions imposed on us by foreign countries. We couldn't impose tariffs on foreign imports, for example, because there was no guarantee that the individual states would go along. And in practice, they rarely did. The third inadequacy that the framers found with the Articles of Confederation was that the national government then could enter into treaties, but they had difficulty enforcing the treaty obligations against states because treaties weren't supreme. There was no supremacy clause. This was particularly dangerous because violations of a treaty could lead the United States into war. This was a concern, for example, with respect to the treaty with Great Britain of 1783, which ended our war with Great Britain. States weren't complying with the obligations of the treaty, and as a result, Britain refused to remove its troops from outposts on U.S. territory. The next inadequacy is that the national government had no direct taxing authority to pay for national expenses. Difficulty raising money to do anything on a national level that would involve foreign relations. And last, the national government didn't have the power to punish offenses against the law of nations. Again, this was particularly dangerous because failure to punish offenses against the law of nations could lead the nation into war. So the framers were keenly aware of these inadequacies with the Articles of Confederation, and many of the foreign relations relating provisions in the Constitution were enacted specifically to remedy those perceived inadequacies. Alexander Hamilton in Federalist 75, for example, criticized the absence of an executive branch in the Articles of Confederation. He said this created difficulties in terms of what he called secrecy, speed, consistency, and accountability, which were necessary to conduct foreign relations. In part as a response to these concerns, the Constitution created an executive branch through Article 2. In Federalist 11, Hamilton argued that the need for a commerce power on a national level is one of those points about which there is least room to entertain a difference of opinion. It severely hampered our ability to trade with foreign nations. Well, Article 1, Section 8, Clause 3 thus gave Congress the general power to regulate foreign commerce. James Madison wrote in Federalist 42 about the need for a national government power to punish offenses against the law of nations. These articles, he said, Articles of Confederation, contain no provision for the case of offenses against the law of nations. And consequently, the articles leave it in the power of any indiscreet member, he's talking about the states, to embroil the Confederacy with foreign nations. The Constitution remedied this inadequacy as well by giving Congress in Article 1, Section 8, Clause 10, the power to define and punish offenses against the law of nations. The Constitution also gave Congress the power to tax, and the Supremacy Clause in Article 6 made treaties the supreme law of the land and binding on states. So the starting point for foreign relations law is the understanding that the U.S. Constitution very much had a foreign relations focus. And this made sense. The United States at the time, remember, was a fledgling nation, relatively weak, trying to avoid costly and potentially ruinous war. So it's important to understand at the outset that foreign relations was important from the beginning. Much of the Constitution has a foreign relations focus. But viewing the historical sources together with the constitutional provisions leads first to an important observation, but also to an apparent paradox about the operation of foreign relations law in our government. The observation is this: when one reviews the distribution of foreign affairs powers in the Constitution, the list of the President's powers in Article 2 looks much more limited than one might expect, particularly when those powers are compared with Congress's fairly lengthy list of foreign relations powers. The President's list, outlined in Article 2, looks pretty short. For example, the Constitution's text grants Congress the powers to lay taxes and duties, to regulate foreign commerce, establish uniform rules of naturalization, define and punish piracy and offenses against the law of nations, declare war and grant letters of marque and reprisal, raise and support the army, provide and maintain a navy, regulate the armed forces, call forth the militia, and through the necessary and proper clause, to make all laws which shall be necessary and proper for carrying into execution those powers. Congress also can regulate the jurisdiction of the federal courts, and Article 1 allows the writ of habeas corpus to be suspended when in cases of rebellion or invasion the public safety may require it. The Supreme Court appears to have assumed in the war on in Hamdi, the first war on terror, or one of the first war on terror cases, that only Congress can suspend the writ. The President, by contrast, has few specifically enumerated powers. The President's the Commander-in-Chief of the Armed Forces, has the power to make treaties with the advice and consent of the Senate, by the way. He appoints U.S. ambassadors, again, with the advice and consent of the Senate, and he receives foreign ambassadors and public ministers. In addition, the President's responsible for taking care that the laws are faithfully executed. So when you compare those few, maybe four lists, or four items on the list of presidential powers, that looks fairly short compared to the long list of congressional powers. So if the observation is that the constitutional text provides the President with fewer specific foreign relations powers than it provides Congress, the paradox is this: given that observation, it seems odd or paradoxical that the President has always had substantial foreign affairs powers. At least in modern history, the President served as the primary actor in the realm of foreign affairs. For example, modern presidents have asserted the authority to proclaim the nation's neutrality with respect to international armed conflicts, to commit U.S. armed forces to battle without a formal declaration of war by Congress, to authorize U.S. forces to engage in covert operations with foreign countries, to enter into agreements with other nations outside the Article 2 treaty process, to terminate a treaty unilaterally, to acquire territory for the United States, to determine which governments the United States will recognize, which foreign governments, and to determine and announce the general policy of the United States, the general approach of the United States to foreign policy. Now, I listed the President's foreign affairs powers in the Constitution. None of those is listed there. So where might the President get that authority? Are there answers to this paradox? Well, there have been several that have been set forward. First, perhaps some foreign affairs powers can be implied from the ones listed in Article 2. For example, perhaps the power to determine which governments to recognize can be implied from the ambassadorial receipt clause. Under international law, receiving an ambassador is the equivalent of recognizing that foreign government. Okay, so maybe the ambassadorial receipt clause gets you to the recognition of foreign governments. Perhaps the power to break treaties can be implied from the power to make them. Perhaps the power to announce a military policy can be derived from the Commander-in-Chief clause. That's the first. Perhaps some foreign affairs powers can be implied from the ones listed in Article 2. The second potential explanation, the potential way to resolve this paradox, is that perhaps some can be explained by Article 2's vesting clause. Article 2, Section 1 says that the executive power is vested in the President. By contrast, Article 1, Section 1 states that all legislative powers herein granted shall be vested in the Congress of the United States. Perhaps the Article 2 reference to the executive power and the absence of the limiting language herein granted includes some powers not specifically granted. So maybe the President's power isn't limited to that short list in Article 2. The third potential explanation: the President's obligated under Article 2, Section 3 to take care that the laws be faithfully executed. Perhaps this obligation includes certain foreign affairs powers. For example, maybe this includes the power to take actions to enforce the United States in its international law obligations. Take care that the laws be faithfully executed. Maybe that's international law. Fourth explanation: perhaps the President derives power from his role as operational head of the executive branch. As the operational head of the executive branch, maybe there are some executive branch type decisions that fall under his authority, within his discretion, by virtue of the fact that he's the head of the executive branch. Fifth potential explanation: perhaps the structure of the Constitution, together with the Constitution's text, makes the President the, quote, organ of intercourse, as Alexander Hamilton called it, between the United States and foreign nations. As Hamilton put it, the President is in the position to act with the, quote, unity, secrecy, and dispatch necessary to conduct foreign affairs. So maybe there's a structural explanation there. The final possibility: perhaps some foreign affairs powers of the United States are not derived from the Constitution at all, but rather come from the status of the United States as a sovereign nation, in which case the President would not necessarily have to find the authority to act under the powers listed in Article 2. Now, a difficult question is, once you say that certain powers are inherent in the sovereign nation, they're inherent in sovereignty, that gets you to the point where you have the point where, this power rests with the national government. We're a national government of limited powers. How does the national government get that power? Well, it's inherent in sovereignty. But that doesn't say among the branches of the national government who has that power. One example is the power over immigration. The Supreme Court has said Okay, that's inherent in sovereignty, but Congress, we all understand today, has plenary authority over immigration, not the president. So those are the possible answers to the paradox, possible explanations for where the president gets foreign affairs powers given the paucity of express textual grants of power. But to say that the president has the power to do something doesn't necessarily mean that he has the exclusive power or the independent power, or what it's sometimes called the preclusive power, to do it. Foreign relations law is somewhat unique in the sense that many of the national government's foreign relations powers are shared by Congress and the president. Or if not shared, their distribution at least somewhat uncertain. The point is that to know whether the president has the constitutional authority to do a certain thing in a given situation, we've got to know more about the relationship between Congress and the president in foreign relations law. That's the topic that we're going to turn to now. The central case, the central authority on the relationship between Congress and the president is the Youngstown Steel case. This is Youngstown Sheet and Tube Company versus Sawyer, the so-called steel seizure case, sometimes called Youngstown Steel. You've been provided an excerpt of the opinion, and I'll refer to that excerpt while discussing the case. During the Korean War, President Truman attempted by executive order to seize most of the nation's steel mills in an effort to avoid a strike. Truman argued, among other things, that uninterrupted steel production was essential to the war effort, and that his decision to seize the steel mills was supported by his role as the nation's chief executive and commander-in-chief. The Supreme Court disagreed and ruled against Truman. Justice Black wrote the majority opinion, but Justice Jackson's concurrence serves as the framework most often used to evaluate the relationship between Congress and the president, particularly in foreign affairs. You've got three opinions excerpted there. You've got Black's majority opinion, a Frankfurter concurrence, and a Jackson concurrence. And I'll say something about each of these excerpted opinions, but I want to start with the most famous, what's thought of as the most important, Justice Jackson's concurrence. The pages aren't numbered, but that's on page 3 of the opinion, is where the excerpt starts. By way of background here, Chief Justice Rehnquist was a law clerk for Justice Jackson, and he served during the term that Jackson wrote this Youngstown Steel opinion. Because of clerk confidentiality rules, we don't know whether or in what capacity Chief Justice Rehnquist, then Clerk Rehnquist, assisted Justice Jackson with the case. And in fact, in a 2001 book, Rehnquist wrote about serving as a law clerk to Justice Jackson, mentioned the Youngstown Steel case, and said, I had very little to do with it. He wrote the whole thing. We don't know whether that's the modesty of a former clerk who's now a judge or whether that's in fact the case. But in any event, given the important role that Chief Justice Rehnquist played in many of the foreign relations issues while he was on the court as an associate justice, and then as the Chief Justice, it's at least an interesting historical turn that in one of the most important foreign relations cases, Chief Justice Rehnquist was serving as a law clerk. Jackson's opinion is important for several reasons. The first reason is that he highlights, I think he really hits this on the head, he highlights the difficulties of reaching firm legal conclusions in the foreign relations field. So in the first paragraph of Justice Jackson's concurrence, he recognizes what he calls the poverty of really useful and unambiguous authority applicable to concrete problems of executive power as they actually present themselves. A century and a half, he says, of partisan debate and scholarly speculation yields no net result, but only supplies more or less apt quotations from respected sources on each side of any question. They largely cancel each other, he says. In a footnote in the opinion, he says, a Hamilton may be matched against a Madison. Professor Taft is counterbalanced by Theodore Roosevelt. It even seems that President Taft cancels Professor Taft, says Jackson. As you all know, Justice Jackson is considered one of the best justices, one of the great justices of all time. But he's also considered one of the best, if not the best, writers in the court's history. And his writing skills are on full display here in this opinion. Justice White used to tell good writers, you write extremely well. Justice Jackson had that problem too. Because sometimes Justice White disagreed with Justice Jackson's opinions. As for the court decisions, court precedents dealing with foreign relations, Jackson says they're indecisive because of the judicial practice of dealing with the largest questions in the most narrow way. The second reason I think Justice Jackson's concurrence is important here is because it offers a useful framework for evaluating presidential power. I'm now on page 4 of the opinion. Presidential powers, Justice Jackson says, are not fixed, but they fluctuate, depending on their disjunction or conjunction with those of Congress. In what he admits is an oversimplified grouping, Jackson offers a three-tiered framework through which we can evaluate presidential power. At the top of page 4 of the opinion that you have excerpted, he has the first category. When the president acts pursuant to an express or implied authorization of Congress, his authority is at its maximum, for it includes all that he possesses in his own right, plus all that Congress can delegate. In these circumstances, and in these only, Jackson says, can he be said to personify the federal sovereignty. If the act is unconstitutional under these circumstances, Jackson says, it usually means the federal government as an undivided whole lacks the power. Then Jackson moves to the second category, when the president acts in the absence of either a congressional grant or denial of authority. He can only here rely upon his own independent powers. But there's a zone of twilight, Jackson calls it, in which he and Congress may have concurrent authority, or in which the distribution is uncertain. Jackson recognizes that this zone of twilight will present difficult cases. Therefore, he says, congressional inertia, indifference, or quiescence may sometimes, at least as a practical matter, enable, if not invite, measures on independent presidential responsibility. And the answers in these difficult cases, Jackson says, are likely to depend on the imperatives of events and contemporary imponderables rather than on abstract theories of law. Jackson's third category, when the president takes measures incompatible with the expressed or implied will of Congress, his power is at its lowest ebb. For then he can rely upon his own constitutional powers, minus any constitutional powers of Congress over the matter. Courts can sustain exclusive presidential control in such a case by disabling the Congress from acting upon the subject. And Jackson concludes this category by warning. This is a pretty big step if a court's going to decide that the president has the exclusive power here. The preclusive power, as it's sometimes called, his independent power could allow him to act in Category 2, where the power is shared. But in Category 3, we're talking about exclusive or preclusive power. That means Congress can't act on this at all. So Jackson warns that a presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution. For what's at stake is the equilibrium established by our constitutional system. Justice Jackson concludes that Truman's actions seizing the steel mills were contrary to the will of Congress, so Truman's assertion of power fails in Jackson's view. The final point I want to highlight in Jackson's opinion is his more general discussion of presidential power, and this is on the last page of the opinion and the last page of the handout that you guys have. In the second full paragraph, the third paragraph carrying over, Jackson recognizes that there exists what he calls a gap between the president's paper powers and his real powers. The Constitution does not disclose the measure of the actual controls wielded by the modern presidential office. That instrument must be understood, the Constitution, that instrument must be understood as an 18th century sketch of a government hoped for, not as a blueprint for the government that is. The Constitution is a sketch, not a blueprint. Subtle shifts, he says, take place in the centers of real power that don't show on the face of the Constitution. The Constitution is a framework for how the government works. Here, Jackson recognizes that the textual grants of power to the president must be viewed in light of the structural and practical advantages given to him by the framework, this sketch, that the Constitution creates. Executive power, he says, has the advantage of concentration in a single head. Of course it does. This was one of the points that Hamilton made in support of the unitary executive, in whose choice the whole nation has a part, accountable to everybody, making him the focus of public hopes and expectations. In drama, magnitude, and finality, his decisions so far overshadow any others that almost alone he fills the public eye and ear. Finally, Jackson recognizes the limited role of the courts in foreign relations law in preserving the balance of power between the two political branches. I have no illusion, he says, that any decision by this court can keep power in the hands of Congress if it is not wise and timely in meeting its problems. If not good law, he says, there was worldly wisdom in the maxim attributed to Napoleon that the tools belong to the man who can use them. We may say that power to legislate for emergencies belongs in the hands of Congress, but only Congress itself can prevent power from slipping through its fingers. What Jackson's recognizing here is that the historical practice of and relationship between the political branches matters a lot in the foreign relations area. Because of the different justiciability doctrines, and by that I mean the different rules such as standing or the political question doctrine or the rightness doctrine, prescribing the types of cases federal courts can hear, courts have relatively few precedents in the foreign relations arena. Often these foreign relations disputes aren't conducive to judicial resolution. They're often battled out in the political process. The political branches have political tools to fight each other, to preserve their own prerogative. As Jackson says in his opinion, that's why we have what he calls a poverty of really useful and unambiguous authority, because so oftentimes it's a product of the tug and pull of the political process, of the political branches working with sometimes and sometimes against each other. The end result is that each branch is primarily responsible for protecting its own prerogative. And courts often, as a practical matter, will defer to the subtle shifts in these prerogatives over time. This is where Justice Frankfurter's concurring opinion comes in, which starts on the second page of the excerpt. I just want to say a couple words about that opinion. Frankfurter also talks about the structure, the importance of the structure of our government. He argues that the separation of powers built into our Constitution gives essential content to the undefined provisions in the frame of our government. I'm now in the last paragraph of his opinion on page 3. The Constitution, he says, is a framework for government. Okay, that sounds a lot like what Justice Jackson was saying. Therefore, the way the framework has consistently operated fairly establishes that it operated according to its true nature. Deeply embedded traditional ways of conducting government can't, he says, of course they can't, supplant the Constitution or legislation, but they can give meaning to the words of a text or supply them. It's an impermissibly narrow conception of American constitutional law to confine it to the words of the Constitution and to disregard the gloss on which life has written upon them. So you've got the text, but you've got to give the text context, the gloss on which life has written upon them. In the foreign relations law context, historical practice and the interaction between the two branches matters a lot. And that's because there's what Justice Jackson said, this poverty of really useful and unambiguous sources and precedents. Put simply, Frankfurter says, a systematic, unbroken executive practice, long pursued to the knowledge of Congress and never before questioned, engaged in by presidents who have also sworn to uphold the Constitution, making, as it were, such exercise of power part of the structure of our government, may be treated as a gloss on the executive power vested in the President by Section 1 of Article 2. Now note, one of the reasons he thinks history is so important here is because a term like executive power needs context. And so the historical practice, the relationship between the political branches, can provide some of that context. Now, remember that he doesn't say, regardless, or he says, he cautions that regardless of how deeply embedded a certain practice is, it can't supplant the Constitution, but it can give a gloss to it. His opinion's been incredibly important since the time of Youngstown Steel for that point. The historical practice matters a lot. Chief Justice Rehnquist wrote in the early 80s an opinion called Dames and Moore versus Reagan, which relied on the point that there had been a long-standing historical practice. Cited Justice Frankfurter. You think Chief Justice Rehnquist was familiar with this Frankfurter opinion? Of course he was. He was clerking for the court at the time. The last opinion I want to say a couple words about is Justice Black's majority opinion, which of course starts the excerpt you have. As important as Justice Jackson and Justice Frankfurter's opinions are, I think Justice Black's opinion is one that's often overlooked here. And it's because of the separation of powers point that underlies, that serves as the foundation for Justice Black's opinion. He makes arguments based on the Commander-in-Chief Clause and the Take Care Clause. But what's really driving his opinion, and my opinion, is the Vesting Clause. The Vesting Clause, I think, is his Vesting Clause argument is doing the work for him. Black's Vesting Clause argument essentially boils down to this. The legislative power is the power to make and change legal rules, such as private rights. Only Congress can do this. because Congress was granted the legislative power. The president, granted only the executive power, can't. The objection on this view to Truman's seizure of the steel mills is that the president had invaded the private property rights of the people who owned the steel mills without legislative authorization. To change individuals' private property rights in the domestic sphere, well, that requires legislative action. That requires the legislative power. The president doesn't have it. He doesn't have the authority to do it. So Black's opinion at base is about separation of powers. And it's about what's the core legislative power, at least in the domestic sphere, which Youngstown Steel was. You can think about the core of the legislative power as being the right to change, the power to change legal rules such as private rights. So that's the Youngstown Steel case, which was incredibly important. It's been incredibly important since it was written, and it still today provides the framework for the relationship between Congress and the president. And this is particularly true when it comes to the war powers, which is the final subject I'll talk about today. The debate about the war powers and the relationship between Congress and the president centers around the question of which powers of the president are preclusive, which president of the powers are independent, and which powers of the president are shared with Congress and can be regulated by Congress. Translated into Justice Jackson's Youngstown Steel framework, the question is, which powers may the president exercise in the face of congressional silence, Category 2, or in the face of congressional opposition, Category 3? There are a few instances here where most agree that the president possesses at least independent constitutional authority, meaning he doesn't need congressional authorization. He could probably do it if he fell into Category 2. The power to direct military operations once a war is started. The commander-in-chief, tactical control of the military seems to follow from that. The power to use force abroad to protect American citizens and American property. The power to engage in the defensive use of hostilities to repel an attack or invasion. But even these fairly uncontroversial presidential powers come with difficult questions at the margin. What if the president uses his control of military tactical operations to act in a way that would expand the scope of the war? For example, to pursue enemy combatants into neutral territory. Think about the Afghanistan-Pakistan border here. What if we read the authorization of use of military force to only allow the invasion of Afghanistan to fight the Taliban government? Does that allow the president to authorize troops to pursue enemy combatants over the territorial line from Afghanistan to Pakistan? That's a hard question. How does one know when a particular use of force turns from defensive to offensive? Right? If you think that the president has the authority to protect the country, to repel an invasion, or to quell an attack, how do you know when that becomes offensive? That's hard also. How does one define the protection of American citizens? Everybody agrees that in the easy cases, the president has some authority to protect American citizens, to use military force to protect American citizens. But what about the preemptive use of military force? Maybe not. Maybe. The difficult questions that come from the fairly uncontroversial starting point don't even get into the more controversial assertions of inherent or independent presidential power. Think here about the power to detain enemy combatants, the power to try enemy combatants by military tribunal. The end result here is that because even the fairly uncontroversial presidential powers can quickly lead to difficult legal questions, and because presidential power in Category 3 is at its lowest ebb, as Jackson calls it, you don't want to be in Category 3 if you're the president, much of the battle in these war powers cases is about into which box does the presidential action fall. Has Congress expressly or implicitly authorized the presidential action, placing that action in Category 1? Or is the action contrary to Congress's will, express or implied, placing it in the dreaded Category 3? Or does the action fall somewhere in between, where Congress has been silent, placing it in this zone of twilight, as Justice Jackson called it in Category 2? This, to a large degree, like I said, describes how the battle has played out when the war powers are at issue, but it also describes how the battle's played out, to a large degree, in the war on terror cases that have reached federal courts. Because the question is one of which box does the presidential action fall into, much of the debate is statutory interpretation. Can the president find some sort of a congressional authorization? Remember, it can be implied, can be implicit authorization for a given action. If you're opposing the action, can you find an implicit rejection of that action in the statute coming from Congress? In the 2004 case of Hamdi versus Rumsfeld, for example, one of the questions before the court was whether the congressional authorization for the use of military force, which was the authorization to use force, the post-September 11, 2001 legislation, it was whether the authorization of the use of force included the authorization to detain enemy combatants. On the president's side, they said, yes, of course they do. You're allowing me to use force. I got to do something when I've got enemy combatants. On the congressional side, or the folks who oppose these detention programs, no, of course it doesn't. Using force doesn't entail detention of enemy combatants. The plurality opinion there interpreted the authorization statute to include the authorization for detention of enemy combatants, at least in a narrow, limited context. And the Hamdi case is a great example of what Justice Jackson talked about as deciding the largest and most important questions in the narrowest way. And because the plurality determined that the authorization statute included the authorization to detain, the presidential detention program, with respect to Hamdi himself, they didn't make a large, broad ruling, but with respect to Hamdi himself, fell in Justice Jackson's Category 1. And so the plurality answered the question in the president's favor. Rasul versus Bush, decided the same day as Hamdi, was also a statutory decision. And the Supreme Court held that the federal habeas corpus statute applied to Guantanamo Bay. 2006 case of Hamdi versus Rumsfeld presented the court with a challenge to the military commission set up by the Bush administration to try detainees at Guantanamo Bay. The outcome again turned on an issue of statutory interpretation, holding that specific restrictions in the Uniform Code of Military Justice trumped the more general terms of the authorization for the use of military force. The Supreme Court ruled against the president, turning on a statutory interpretation question. Congress responded to the statute-based ruling by enacting a statute, the Military Commissions Act, that got around the court opinion. The Boumediene versus Bush case admittedly is a bit different. That's a constitutional ruling, not a statutory ruling, but Congress still could have suspended the writ of habeas corpus. The court merely held that it didn't. The point is that though the court will get involved in these types of cases, the two political branches together have quite a bit of power when it comes to foreign relations. And using the Youngstown Steel framework, much of the battle is determining into which category a certain action falls into. And that's where I'll leave it for now. Thank you, guys. I don't know how these work. Do we do questions or? Till I get tired and fall over. Yeah, I'm happy to accept questions. I don't know how satisfying my answers will be, but yeah, Gary. You're going to ask about the legal-political distinction, contest that? Mm-hmm. Mm-hmm. Well, for one, I don't think they've been complete wimps. I mean, they passed the War Powers Resolution over Nixon's veto, which is seen as a tremendous assertion of congressional power. In part, I think everybody agrees that part of it is probably unconstitutional, at least after INS versus Chadha. So I don't think they've been complete wimps, but presidents have been pretty fierce about preserving their prerogative also. For example, every time they report in a way that's required supposedly by the War Powers Resolution, the president say, we're issuing this report consistent with the War Powers Resolution, usually with some footnote that every president since Nixon has felt that the War Powers Resolution was unconstitutional. But to answer your question directly, I think it has to do with the structural frameworks of the different bodies. Pretty easy for the president to protect his prerogative. More difficult for Congress, a collaborative, collective body, to do so, where you can, in any given administration, there's going to be some portion of the Congress who wants the administration to infringe on Congress, perhaps, if that allows the administration to do what the members of Congress would like to do. So it's a hard question. I don't think Congress has been complete wimps. I do think that the structural framework of the two different branches tilts in favor of the president in these battles, but that's not to say that a consistent pattern of congressional assertions of power aren't enough to preserve their power. I think you've seen a lot of that in the Bush administration. I mean, there's a lot of talk about aggressive assertions of executive power, but Congress has done a pretty darn good job of fighting back as well. So, I mean, think about their powers of oversight and things like that. So, any other questions? All right. Well, thank you, guys.